So it's a risk that you have to take, but depending upon the sentence, if it's life sentence, then maybe you've got nothing to lose, and maybe well then it wouldn't be tried in a magistrate's court, it would be tried in a Crown Court. But then even from a Crown Court you could appeal in the High Court if you had grounds to. And if it was a life sentence, then you would have nothing to lose, so you might as well go for it anyway if you had the grounds. So there are other sections in the High Court, including the Chancery Division dealing with probates, bankruptcy, and the Divisional Court dealing with appeals from the County Court. So the Divisional Court deals with the appeals. The Queen's Bench deals with the Commercial Court, and the Administration Court, which deals with overseeing that the legal legislation is actually being adhered to correctly. So again, the High Court has many different sections to it, and these you need to explain briefly. And then you have as we've said, above the High Court you have the Court of Appeal, and then above that you have the Supreme Court, where that is the final decision. So when you are looking at this question, obviously the second half of the question you have to explain the court system. Explain the court system briefly, not in great detail. We don't want pages and pages. I mean, for P2 we're looking for approximately 500 words. So 500 words, we can see we don't want too much detail, but you need to explain the different court systems. So on the criminal matters we're looking at magistrates' courts, Crown Court, High Court, Court of Appeal, Supreme Court, and then on civil matters we're looking at tribunals, County Court, High Court, Court of Appeal, and Supreme Court. Now, we still haven't finished the question. We still have to say and law and how statutory and common law is applied in the Justice Court. So now we need to give an example of statutory legislation, an example of common law legislation that has been applied in the Justice Courts. So if we look, for instance, on the criminal matter, if we say, for instance, the Firearms Act, the Firearms Act says, and it's been amended many times and revamped, to include people not being able to hold a gun or have a gun, or in today's age, even a taser, and unless you have a license to hold one. But if you don't have a license to hold one and you are caught, for instance, with a taser on you, then what would happen? You could actually go to a magistrate's court. You would go to a magistrate. You would be held. You would be questioned, and then you'll be asked if you want a solicitor, and then you may be held in custody, or you may be let go and asked to come back to the station at a later date. At which stage, if you're asked to come back at a later date and you haven't been charged, you may be charged when you come back to the station, and when you're charged you'll be giving a date to come back to the court. Now if you were caught in possession of a taser and it went to the magistrate's court, it could be held and determined by either the judges. More likely you want it to be held by a district judge, because a district judge could actually, or would have the experience to decide on the outcome of the case, whereas the Justice of the Peace may not necessarily decide and may just put it forward to the Crown Court. So here in the Magistrates Court, it can be tried, or it could be put forward to the Crown Court. If it's put forward to the Crown Court, then the Crown Court, you would have a jury, and you have to put your facts and point of view if you had pleaded not guilty. And then your jury of your peers would judge if you were guilty or not guilty at that time. Now, you could then appeal if you wanted to into the High Court. So again, give an example here of how, like the Firearms Act, if you were caught with a firearm and you didn't have a license, and it would go through a criminal side either to the Magistrates Court or to the Crown Court, and then where you could appeal to the High Court if you were found guilty. So again, give an example. On the civil side, if we look at Donohue versus Stevenson, 1932, again here, what happened here was that there were two friends who were going to they were in a train station in Paisley in Scotland, and her friends, they went into a cafe because they were feeling hungry, and in the cafe Mrs. Donohue sat down at a table and she asked her friend, as you would, to buy her some ice cream and ginger beer. So her friend went to the counter and her friend paid for it and bought it for her. So Mrs. Donohue didn't buy it, but her friend bought it for her. So her friend bought her some ice cream and ginger beer. So she came back and bought the ginger beer and ice cream to Mrs. Donohue, and then Mrs. Donohue poured some of the ginger beer over the ice cream and was eating the ice cream, and at the same time she was drinking the ginger beer. Now, and then she kept eating the ice cream and ginger beer, and when a little bit was left in this opaque bottle, because in 1932 you didn't have cans but you had bottles, and the bottles you couldn't see through the bottles, so they were opaque, and here Mrs. Donohue saw at the end of the ginger beer, when it was almost finished, a decomposing slug, a snail in her ginger beer, and she felt physically sick. Now the difficulty with this was that Mrs. Donohue didn't actually buy the ice cream and ginger beer, so she didn't have a contractual obligation, a contract between Stevenson, the company that was filling the ginger beer into the bottles, and herself. Because there was no contractual obligation, it was a little bit difficult in terms of her suing. She was actually suing for £500. £500 in today's money is equivalent to about 2 years ago, about £27,000. So there is another case, Ansell versus Waterhouse, 1817, which looks at omissions and acts. So that couldn't actually be used because there wasn't any unilateral duty of care owed. But nevertheless, Mrs. Donohue took this to court. And it was found that, and it was tried and it went to the High Court, and it was found that Stevenson actually owed a duty of care. A duty of care to make sure that all reasonable acts and omissions, which were reasonably foreseeable, were necessarily taken care of, not to harm anyone. And this had established the neighbour principle. The neighbour principle establishing that you must not harm your neighbour in any which way, shape or form, which is reasonably foreseeable. And therefore established negligence. And this today, the negligence is based, and all negligence that we see today, if we trip over a pavement, if we have an accident on the motorway, or if a car pulls out and hits a motorcycle, again, this is all based on negligence, and one can sue someone else without having a contract between that person. And it's based on this case of Donohue versus Stevenson of 1932. And the case basically had four main principles. One, it had to establish, was there a duty of care? Well, did Stevenson owe Mrs. Donohue a duty of care? Absolutely. Stevenson owed Mrs. Donohue and anyone else who bought their and drank their ginger beer a duty of care to make sure that there was nothing else in that drink apart from ginger beer. Were there damages? Yes. Mrs. Donohue was physically ill. She went to hospital. She was physically sick of the thought of what she had just drank. Sorry, the second one was there was a breach of duty of care. Yes, there was a breach of duty of care because there was a snail in the drink. Was there causation? Yes. Causation. Were there damages? Yes. Mrs. Donohue suffered damages. She was physically sick and physically ill. And was there remoteness of damage? Was her illness only caused by the fact that she drank that snail and that drink? Yes. She was only physically sick and physically ill because of the drink that she drank, the ginger beer with the snail in it from Stevenson. So again, it has established those four rules. There was a duty of care was required. They had owed a duty of care to people drinking their product. Was there a breach of duty of care? Yes, there was a breach of duty of care. Was there causation? damages? Yes. That resulted from this? Yes. She was physically ill. And was there remoteness of damage? Absolutely, because this was only as a direct result of her drinking the ginger beer with the snail in it. So again, there you've explained the case, and we've explained that this would be seen in the county court, but in this case of Donohue versus Stevenson, actually went to the High Court. So again, going back to the question where it says, explain the role of government in lawmaking and how statutory and common law is applied in justice courts. Just to recap, we're looking for, again, approximately 500 words. And we're saying that the first thing you need to do is to briefly mention again the different types of bills, being public bills, private members' bills, private bills, and hybrid bills. You may want to mention a white paper in terms of outlining what the bill is. And then you have to explain the process being a first reading, a second reading, committee stage, report stage, and then a third reading. And then that reading going through to the second house, and then back to the first house for amendments, and then to the Queen for the royal assent. And then that's the first part of the question done. The second part of the question, you need to first explain the justice courts. On the criminal matters, we're talking about magistrates' courts, Crown Courts, High Court, Court of Appeal, and the Supreme Court. And then on civil matter, we are talking about the